talking about today is how do we regulate privacy in a new era where online intermediaries and platforms of various sorts play such a defining role in the information ecosystem. So this is quite a topical, very topical issue generally, but it's also a very topical issue on the law and information course for those of you who may be interested in that fact. But without any further ado, I will pass over to Joris now.
Thank you, David. And it's my great pleasure to be here and to give a talk. I actually haven't been at the University of Cambridge before, and we were trying to make it happen earlier in the year, and it didn't work. And I'm very glad that it came about like this. So I'm giving a talk on platforms as privacy regulators, data privacy regulators. That is building on work that we did on a project on smartphone ecosystems. It was a project called Transparency Bridges, and the idea was to look at the role of smartphone ecosystems in ensuring privacy protections, in particular transparency about the collection and use of personal data by smartphone apps. And that is a project that has just recently come to a close. In addition, it builds on work that I've been doing in Brussels on a recent case law on the definition and application of the definition of the controller in data protection law. The controller is the entity that is responsible, is like assigned all the main responsibilities in the data protection regime. And I'm very interested in that very basic question. Generally speaking, I'm very, very interested in all the threshold, like basic definitional questions of the data protection regime. And finally, I think it builds also a little bit on work that I've been doing in a policy context. I was appointed to a recent EU Commission new committee of experts. It's called the Observatory for the Online Platform Economy. And this is an expert group that has been assigned to look into the issues that the regulation on fairness in business to platform relations is trying to tackle. So this is a regulation that is trying to deal with fairness issues in the way that, let's say, business users of a platform like Amazon are being treated. Is there like differential treatment? What kind of transparency should you be getting about data? And what is very interesting is that this type of regulation also has somewhat of a contrast with the data privacy interests of the users, like the business users versus the users. So I'm working on that, this topic a bit in that context as well. So platforms as privacy regulators, as just a quick overview, I want to talk a little bit about those notions, like the platform and the regulators notion, quite loosely. I do this. It's mostly conceptual work. Then I will give some speak about some background and developments that I think can help to illustrate or to clarify this notion or this idea of platforms as privacy regulators. In the work that we're doing, and we have a draft paper now, we look at the Facebook ecosystem and smartphone ecosystems in particular. But I want to say a little bit also about the GDPR and the recent case law on joint responsibility under data protection law. Then I want, in the third part, talk a little bit about what are these kinds of roles and functions of platforms as privacy regulators, like distinguish a few general roles and functions, and then finally end with, and that should really also lead us into some discussion, I hope, on what should be the role of platforms in privacy law and policy. I mean, from the start you can obviously tell that they have kind of a dubious role, like this idea that these types of platforms, they were going to be the privacy regulators. In fact, they're maybe at the forefront of eroding privacy. But that is exactly, I think, the tension point that makes this interesting topic. So platforms as privacy regulators. So there's a very clear rise of what you could call, what people call the platform model in governing all sorts of contexts. But it's rather difficult to really strictly define what a platform really is. There's all sorts of definitions or approaches to this, like the multi-sided platform market. Notion from the economics literature is a good one to use, but in the end I think what I would like to do is use a fairly broad definition that opens it up to also like little bit more complex entities. So my definition is an internet-based service or service ecosystem that provides the foundations for other data-driven businesses to operate and they have considerable influence over the functioning of the broader service environment that they help to facilitate. And it's like they're in this position that they can extract value out of this position. So there are different types of platforms. Just a few of them that I put here, like the audience and speech platforms is one distinct type of platform. The audience platforms, Facebook, YouTube, you know, that are connecting content providers and advertisers on the one hand with end users. Developer, technical platform, innovation platforms. You know, those are, you know, like software ecosystems, you know, like the Android and the Apple environments for developing apps, all sorts of other like cloud development platforms, and then the market platforms, like they're kind of their own category. And then you can broaden it out to all sorts of other matchmaking types of platforms that exist. The complications, so a lot of the platforms have very unique characteristics, so you can throw them all in one bucket, but to really understand these ecosystems, it's really worth looking at them like by themselves. Furthermore, and I think this is a really important one, it's really important also for policymakers, is that these platforms, they exist in this very networked environment. And it's not that we have this very neat constellations of you have one platform and then you have users on two sides, but a lot of these platforms, like platforms tend to be very interlinked with one another, and there's all sorts of other services that are being integrated, and sometimes they're part of the business, sometimes they're like existing on the outside. And yeah, so there's a large number of, it tends to be a large number of ancillary services that makes the platform ecosystem, that makes the ecosystem work. And so altogether, it is rather more complex than this kind of neat configuration of a platform with users on both sides. So as platforms, as regulators, I think we can all recognize from coming from a whole range of different areas that there's continuous pressure on platforms to take on various types of regulatory functions and across a whole range of different regulatory areas. So copyright and intellectual property enforcement, I think, is a very clear and easy example that we know about. And it's just recently in the EU's copyright and the Digital Single Market Directive that like additional kind of regulatory functions were imposed on some of the platforms, on the user-generated content platforms in particular. So in the new EU terrorism content regulation proposals, we see also an increased role for platforms through proposed proactive monitoring obligations and this whole idea of like terms of service referrals procedures. So the whole idea is that actually now the Commission has proposed a new notion, it's like what's called terrorism content. Now, this is actually a rather weakly defined legal notion. It's like if you start scrutinizing it from a legal perspective, it's somewhat problematic, but they need to create this notion to start connecting also to the way that platforms would define this type of content themselves and allow law enforcement authorities, like competent authorities, to send referrals. And the whole idea of the referral is that law enforcement authority says, this looks like something that falls in your category of terrorism content. You know, so you start to have like this definitional power, you know, this whole idea of like relying on the definitions, relying on those types of governance functions of the platforms. There's a lot of discussion, is like at the moment this proposal is in the trialogue procedure in Brussels. More recently, you see in the competition area, you see quite a bit of discussion about platforms also as regulators. And there's this idea now that platforms should ensure fair competition between the different business users on their platform. So this is discussed quite well in the recent expert report that was commissioned by Vrije, that came out earlier this year, somewhere in spring. And then finally, this fairness in business to platform regulation, where there's transparency obligations imposed on platforms vis-a-vis their business users. So on background and development. I want to first go for an example that is, both examples are from the US. I think that it's interesting to look at the US because they have been, I think they've been quite early to look into this role of platforms as regulators or kind of frame them as such. And the first example is about Facebook. So this is the situation which Facebook, which is like, you could say this is an audience platform. We could say from a user perspective, it's like a speech platform. This is where like a lot of like discussion and social communication, but also like maybe public discussion is taking place or semi-public discussion. But I think what we have seen over the last years is that, and some people maybe realize that already, is that Facebook had effectively turned its operation into, they basically realized like a very advanced and really big data broker operation where they were collecting a lot of data on people and opening that up to all sorts of business users to do things with that. Like Cambridge Analytica is very close to home, I imagine. And I'm sure that there's been a lot of discussion about that. It's like I just wanted to show, a little bit conceptually like how that works. It's like you have these settings in the background, and basically Facebook with those settings like creates this environment where businesses can in the end just get access to all sorts of data. And like there's all sorts of ways in which you can adjust these settings. You can say only my friends should see that or no one. But the way that Facebook was going about this, in the end, like this is what the FTC concluded already in 2011. There was a complaint, that was like preceding what is it called? Their agreement that they end up making. That they done now lately they ended up agreeing to pay a $5 billion US dollar fine for breaking the agreement. So here's from the complaint. It says that Facebook represented that through their profile privacy settings, users can restrict access to their profile information to specific groups, such as only friends or friends of friends. And in truth and in fact, in many instances, users could not restrict access to their profile information to specific groups, such as only friends or friends of friends. Instead, such information could be accessed by platform applications that their friends used. Therefore, the representation set forth in paragraph 17 constitutes a false, misleading representation. So it's like one thing, of course, that's already happening here is that all these settings are about it's all about the social. For users, there's this representation of this is a social space. This is all about managing social relations. Where Facebook was really building this gigantic data brokerage business and making this platform very, very, very attractive for all sorts of applications to harvest a lot of personal data. So here are a few other parts of that FTC complaint. These are my summaries. So Facebook made it seem to users that platform applications would only get access to such information necessary for them to operate, while in many instances it provided applications unrestricted access to information they did not need to operate. And it made it seem to users that it did not provide information to advertisers. Oh, that was my. So I have this thing where Google keeps on popping. So Facebook made it seem to users that it did not provide information to advertisers. Yeah, it's listening. Yeah. While it did in fact provide advertisers with information about its users. And Facebook operated a verified apps program, making it appear to users that such verified apps were checked for security issues and compliance with Facebook standards. So they had this whole program in place that say they were looking at apps and verifying them. In reality, Facebook did not undertake any additional review on these apps compared to other apps. So I thought that's pretty bad. So this is David Vladek from Cambridge Analytica and the consent decree. So that was this was part of the consent decree. So after the scandal, this was one of the big questions: did they break the consent decree? And so the decree he concludes that this decree thus permits Facebook users to continue to share information, but it forbids third parties from obtaining a user's private information unless the user is giving notice and consent or has enabled privacy settings that allow broad sharing. So, well, in the end, like, it was very clear that Facebook had been operating in a way that was not in line with the consent decree, and had continued to share quite wildly the information of users in ways that was not in line with their statements to users. So they were not doing a very good job at being a privacy regulator. So on the mobile app platforms, so this is an area we looked at, and like when I started doing this work on the mobile app ecosystems, I was like, oh, like I had been doing a lot of work on search engines and like trying to really understand like what is happening with search, how does it work technically, how does it work economically, what are the business models, and like then it seemed like the smartphone area was like super interesting to look at, and I thought like with some investment and some time, you know, after a few years, I was really start to understand this, and it's like. And then now still, this is like, this area, I have to say, just like, it is like immense. These are gigantic ecosystems with a lot of different things playing into each other. And it's like the complexity is just enormous. No. And then of course, like one of the major issues from a privacy perspective is you have these platforms, you have phones, you know, that have all sorts of sensors, they allow you to collect a ton of data. You know, and then all sorts of other services run on top of it, all sorts of libraries help you to do things with like the information that you can extract. And the smartphone ecosystem providers, Apple and Google, they're kind of sitting on top of that. You know? And they're organizing these spaces, and they're like basically like dealing with all sorts of trade-offs, including privacy trade-offs. Trade-offs on the one hand, you know, like users having a certain amount of privacy, have a certain privacy expectations maybe, using their phones, using all sorts of apps, and maybe also relying on the platforms to do a good job, you know, in organizing for certain privacy conditions. And on the other hand, like these remarkable data-driven opportunities for business, you know, like for all sorts of apps. And so what's, when you look at the legal discussions, like the kind of big wave, the first big wave of discussions around like from a regulatory perspective started around 2010, 11. And then at some point in the US, there was an interesting initiative, and that's like called the Joint Statement of Principles from 2012. And this came out of California. And the idea was actually to enlist the large tech companies, including what we now know are the like emerged as the dominant smartphone ecosystems, Apple and Google Android, enlisting them in this role of policing for privacy. So this is the California AG, which is now running for president actually on the Democratic side, Kamala Harris. She was on the forefront of this. So they agreed to create creative and forward-looking solutions that give consumers greater transparency and control over their personal data without unduly burdening innovative mobile platforms and application developers. So it's really about like striking this balance. They clarified that they do not seek to impose any binding obligations on the platforms or affect existing obligations under law. So it's like they really tried to make this a self-regulatory endeavor. And then develop the terms of service of platforms as instruments of privacy regulation, including a promise to allow for reporting and engage in enforcement related to non-compliance of apps with relevant contractual restrictions by platforms, in addition to non-compliance with the law. So it's really enlisting these platforms very explicitly into this regulatory role. So that was also picked up by the FTC when they had a report on mobile platform privacy disclosures. And this may be important to realize in the US, if you look at like a comparison to data privacy regulation in the US and Europe, transparency is like really on both sides. It's like that's an agreed upon principle, you know. So in the FTC, it's like from all the fair information practice principles, they have been on transparency, they have been kind of really giving most of their strong recommendations. So So this is why in the mobile privacy context, also the FTC has been focusing on the transparency and disclosures in particular. So they clarify that platforms are gatekeepers to the app marketplace, and they possess the greatest ability to effectuate change with respect to improving mobile privacy disclosures. And then they have a whole bunch of recommendations in that report. They should implement just-in-time disclosure and affirmative consent mechanisms for sensitive data. So this like really, that becomes a technical project, you know, like you need to design things in the platform that allows apps to do things in a particular way. Maybe also just to clarify, if you look at like the smartphone ecosystem as a platform, you have on the one hand, you have the operating system, you know, like you have for Google, you have the Android operating system, and app developers develop their apps to run within that, you know, environment. And that operating system has all sorts of APIs that you can use to get access to particular data points on the phone, you know, all sorts of data that is stored there. Oh, and then, a crucial element there is under what conditions do those data become available to app developers. No, and so they need to, or they can design for that. You know, everything could just be open. You know, it's like, okay, they take no responsibility. That probably wouldn't work at all. Like people wouldn't like that. So they have designed certain safeguards. They have designed certain mechanisms. And then the question is, for what type of data should you have? What mechanism, or what are good mechanisms to design? So there's a lot of work on that. And there's like here, there's this kind of clear pressure to have just-in-time disclosure. So it's like at the moment that an app starts to access a particular data point, there needs to be something showing that. You know, it could be a little like icon on the top of your screen, you know, like you have these kind of things for location data, for instance. They also should develop privacy dashboards. This idea, like this place where you can go and see everything that's happening to your data. Consider the use of icons. That is still not really implemented, but there has been this idea that the smartphone platforms, the app distribution platforms could have certain privacy icons. So when you look up an app in the App Store, you will see, you know, what kind of like privacy characteristics an app has. And it would like that's a quite interesting place to do that. It was like you could have like because they have the central point, you have a rather quick way to kind of standardize privacy icons. Also, they impose the contractual requirements, reasonably enforce these provisions, and be more transparent about their review process for the apps. That continues to be a big issue. The app ecosystems, the smartphone ecosystems do quite a lot in reviewing apps and throwing off apps. But what exactly they do and what their standards are, it's rather opaque. And then finally develop do not track settings for the mobile environment. At the time there was a lot of discussion about the do not track standards. So really a clear example where platforms are put into this regulatory role. And that has also carried over, like, you know, many times, like the kind of the regulatory status quo, or the kind of the way in which like the US landed on how to go about things, carried over also quite a bit to how things have ended up playing out in practice in the European context. So I want to talk a little bit now about platforms and data privacy under the European data protection framework. So under the European, who is not fully familiar with European data protection? There's a few. So I'll explain a little bit the basics. So under data protection law, the first question that I would say is like the first question that you ask is like, is there any processing of personal data? You know, it's like that's kind of your starting point. And personal data is a rather broad notion. It's any information that relates to an identified or identifiable natural person. So once you have established that there is processing of personal data, your next step is that you need to find the entity or entities that are responsible for the obligations under data protection law. And this is a very crucial step, but it's a complicated step. The responsible one is called the data controller, And the definition is this data controller is the one that determines the purpose and means of the processing of personal data. This is not necessarily just one entity. It can be alone or jointly with others. It can be quite complex configurations. That was always the case. It was never the case that that had to be a single one. It could be joint control. But over time, let's say over the last 30 years, we've moved to a situation where we had, predominantly speaking, we had more standalone information systems for which it was relatively clear why they were there and who was responsible for putting those systems into the world. By now, we are in a situation where a lot of those standalone information systems, they have become cloud-based services, and they tend to be integrated with all sorts of other services. And we're in this very complex networked ecosystem of services that are interlinked, and typically the personal data is also flowing in complicated ways between those different services. So this whole alone or jointly with others has become a difficult part of the GDPR and applying it, also in the Data Protection Directive. So we've had guidance of the Article 29 Working Party on these notions, and we have some comparison to the Data Protection Directive. We have some clarifications on this notion in the GDPR. So, like I was saying, the joint controller notion, it's really challenged by a shift from relatively well delineated information systems to all sorts of cloud-based networked service environments. So in this context, it becomes also very interesting then to ask, where does this kind of platform fit into that configuration? We only have one notion under data protection law. We only have a controller, then we have what is called a processor, and then there are producers, they're kind of on the side. So the question is, does European data protection law provide for any obligations for platforms, acting as platforms under the law? So the Court of Justice in Luxembourg has started to run into this question in a number of cases. So one case that you must be very well aware of, partly also because of David's work in this area, is the Google Spain case. And this was, so in this situation, the question was, is the search engine, can that be considered a controller for the personal data that it's processing in its index? And I mean, first of all, obviously it's like the search engine is crawling the web, it's gathering all sorts of personal data, and then it's making an index, and then in response to queries, it's like those personal data also enter the search results. And so that was a very complicated question to answer. I was always asking my students, it's like how to deal with that, and before the ruling, and I actually was advising the Dutch Data Protection Authority in 2007 and 2008, at the time that they were drafting together with others in Article 29 their opinion on search engines and under data protection law. And so the problem is you do not have an easy escape under data protection law to end up concluding, that an entity is a controller. You don't have something like you have under the copyright law. You have this kind of transient thing, like you're not really doing this, you're kind of passive. Or we don't have provisions like that in the under data protection law. And so what Article 29 ended up doing is saying, well, they are a controller, but then you have to be careful with imposing the obligations. And but Court of Justice, and there were all sorts of arguments. Google also made the argument, we're not a controller at all. We're just like, we don't know what's personal data and other types of data, and we are just kind of, we're not necessarily interested in that. And it's really the user, and it's really the source of the personal data. Those are really the active controllers. but the Court of Justice disagreed. And then they imposed this right to request deletion of specific search engine results for people search queries. So, so the Google search platform ended up being considered a controller for the personal data processed in search results. So then, more recently, we have the Wirtschaftsakademie case, and this is a case that is about exactly about this notion of joint control. Actually, the background of the case is that the German court was asking if there's some form of like possible contributor liability, and they wanted to basically know if that how that would fit with European law for them to conclude, you know, maybe there's like a data protection violation, but then there's another entity that is contributing to that violation, and what is the responsibility of that entity? And then like when they asked that question, the court said, no, this is like no contributor liability thing, they're just a controller in the first place. You know, like, so they're actually, so they end up looking at the business user, an organizational user of Facebook. So this was like, I think some kind of professional school, the Wirtschaftsakademie. And they were using Facebook to reach an audience. And then the Schleswig-Holstein, one of the regional data protection authorities in Germany, they went after this Wirtschaftsakademie organization for using means of reaching users that was not in compliance with data protection law. So this data protection authority took a rather aggressive stance, and interestingly, they didn't go after those, like the platform that was offering means of processing personal data that were not legal. In particular, they were not, Facebook was considered not to be transparent enough about what's happening with people's data. And, but they went after the organization. And part of the reason for that is because of jurisdictional rules. So the German data protection, that regional data protection authority couldn't really go after after Facebook, because Facebook is in Ireland, but they have jurisdiction over this organizational user. So it would be the same if you say like the Android ecosystem is not compliant, you know, like you're not allowed to distribute your app to users in Europe. This is also something that the theory has been furthered in the data protection community, for instance, with respect to governments. You know, like government actors that publish apps, they should be, you know, like they should not rely on these ecosystems for the data protection part of things. So it's like, so what happens is its organization is using this Facebook fan page, and then is considered to be a joint controller with respect to what Facebook does with the audience data. And in particular also because Facebook has all this kind of audience analytics, and those audience analytics are there to also serve those organizational users for them to have information about the visitors of their page. And so the court concluded that those organizational users are jointly responsible for the processing of that personal data by Facebook. So suddenly the Facebook platforms has millions of joint controllers. Then a third case on this, which is like the Jehovah's Witness case, which is quite significant. And in particular, that case concluded that you can be a controller even if you don't have access to the data at all. So I thought this is a little bit counterintuitive for myself. I didn't expect that. I always had the sense that the data protection law was getting very close to what is actually happening with personal data. But in this case, they kind of abstract away from that and they say, well, the organization is can be still considered a controller, even though it doesn't have access to the personal data that are processed by the individual members of the organization in the context of like Jehovah's Witnesses door-to-door preaching activities, collecting information on people that they speak to or not speak to, going door-to-door. And then finally, I should have adjusted that, but this is the Fashion ID case, and there was a ruling on that recently. And this was on the question of joint responsibility of websites for the processing of personal data by third-party trackers. So it's like all sorts of websites, they have implemented Facebook buttons, you know, and that leads to like tracking by Facebook. And then the question is that website entity that is implementing that button, what responsibility or relation does it have under data protection law to the processing of the personal data by that third party that is being integrated? And this is a very significant question because typically speaking, whatever app you use or whatever website you visit, there are a ton of these kind of third-party services that are being integrated. You know, and it's not only the advertising, but it's all sorts of developer tools. It's really a whole range of different services that tend to be integrated in, you know, any type of offering that you will find online or on your mobile phone. And so in the Fashion ID case, there were two questions. First of all, is that website jointly responsible under data protection law? But then there was also the question about the division of responsibilities. You know, because then, of course, once you conclude that you're responsible, there's a ton of different responsibilities. You know, let's say there's a responsibility to be transparent towards users about what's happening with personal data, but there's also an obligation to conduct a data protection impact assessment or to ensure data protection by design. There are responsibilities to respect data subject rights. So it's clear that like in these configurations of joint responsible actors, the question of who gets to do what is also quite important. So in this Wirtschaftsakademie case, like I said, like the fan page is considered a joint controller. And it's like, it doesn't matter that the fan page, they only get access to the results of what Facebook is processing. It's actually enough that they're part of making it happen, you know, and also part of making it happen in a very specific kind of way. It's like those people would have, if they would like, they want to get information about Wirtschaftsakademie and they go to Facebook. Like if they would be going somewhere else, if they would just have their own website, there wouldn't be any processing on Facebook. You know, this kind of reasoning that the court ends up using. And I think here what is very important from a like bigger picture legal perspective is the court ends up using this criterion that it's used also in the Google Spain case, which is the complete and effective protection criterion. And so it ends up casting a very wide net on this question of responsibility. The reasoning being, we don't want anybody to escape, you know, like that's also what happened with the Google Spain case. We can't like just have this entity that has such a large impact on privacy to escape these obligations. So the implications are that for a lot of systems, there will be two or many more controllers jointly responsible under the GDPR. And the obligation in the GDPR and joint controllers there is this obligation then to agree and to coordinate on compliance with specific obligations. And there's really very little guidance how to go about this. So I spoke about this recently with someone that was quite heavily involved in the drafting of the GDPR. And these cases came about under the Data Protection Directive. And like, there are really some issues here with like, you know, how is this going to work in practice? How do you imagine this? And they didn't see a problem at all. And so the reason why they don't see a problem at all is because they stipulate it has to be done. It has to be organized. And so so it's a very interesting situation where they legally it's true. And from an enforcement context, it's true that there is no problem. You can always say, well, like basically say you're all responsible and you should have it organized. And then there's several liability as well. You know, but there is no theory of how to operationalize those obligations. You know, there's no theory of like, okay, how is that actually going to work in practice? That's just left to the market. No, so that leads to a very, very interesting coordination problem. So this is going around on Twitter. You're a controller. Everybody is a data controller. It's like I think this is Michael Veal or Jeff Ausloos they were posting this. So I have a few quotes from the opinion in the Fashion ID case because I think they're quite interesting and kind of fun. So because this is a case that comes after, and I mean, it's kind of obvious if the law results in these kind of outcomes. This is like you start thinking, like, okay, where's the boundary to this? So Advocate General Bobek did that. To the dismay of quite some data protection specialists, they were like, he's totally going off the tracks. Why is he like, he should just apply the law. He should not go into all sorts of like philosophical theories. But he did. So will effective protection be enhanced as everyone is made responsible for ensuring it? That, in a nutshell, is the deeper moral and practical dilemma demonstrated by the present case and expressed in legal terms by the scope of the definition of joint controller. A long time ago, the fans of a certain sci-fi franchise might wish to add, in a galaxy far, far away, it was cool to be on a social network. Then gradually it started to be cool not to be on a social network. Nowadays it appears to be a crime to be on one, and for which novel forms of vicarious liability have to be put in place. And this whole point, like actually this whole question of contributory and vicarious liability, this is, I think, very, very, very interesting. So what you see has happened is data protection law has been very broadly applied. This is kind of cover-all law. It's like Nadia Purtova calls it like the law of everything, and it just applies to basically everything nowadays. And that also meant that you can start applying it to just a whole variety. This is a swath of different legal issues, including all sorts of reputational issues online and all sorts of issues to do with all sorts of power dynamics that have some like relation to data, which most power issues have nowadays. And the thing is, though, that the basic design of data protection law, it's very basic. They have this notion of personal data, then they have processing notion, but there's no distinction in the law based on any kind of processing types of activities. It's not, if you're collecting data, then you have these obligations. If you're publishing it, you have this. It's like the bucket is full. Everything you can do with information is in processing, so it doesn't help you with anything. And then you end up with these controller notions, which are basically the controller processor notions, which are from the time of mainframe computing. These notions, they were developed in the 60s, 70s. And then it doesn't have any kind of robust like theory of responsibility or liability, that we have under tort law, or that we have under like, and Europe has been pushing this law as like, it's basically a fast track harmonization kind of thing, and then the court has been always pushing back against any kind of exceptions. We have from the Lindqvist case and from these kind of cases. The German courts really thought this is like a contributory liability type of constellation, and that would make quite a bit of sense. And they would have had like the legal tools under the national German law to deal with these types of questions. You play a role in some unlawful activity. How do we deal with that? But they are just putting it all under the European law header without having any like proper legal instruments to deal with these kind of questions. So then he adds, like, a skeptical person from the more eastern parts of the European Union might perhaps suggest, considering his historical experience, that effective protection of something tends to dramatically decrease if everyone is made responsible for it. Making everyone responsible means that no one will in fact be responsible. And it could certainly be suggested that for the exact allocation of responsibility amongst the potentially rather numerous joint controllers, contracts should be concluded. This would not only provide for the allocation of responsibility, but also identify the party that is supposed to comply with each of the obligations, including those that can be physically exercised by only one party. So if not everyone is to be made responsible, who should be made responsible then? Or, if everyone is made responsible, which entities will be in the best position to ensure the proper division of obligations between joint controllers and coordinate and conclude the necessary contractual arrangements? So that is, I think, clearly pointing to the platforms. And like what's very interesting, like in reaction to some of these rulings, Facebook updated all sorts of terms and conditions for the business users, and they impose all sorts of new obligations, you know, to deal with this kind of coordinating role between the joint controllers. I think I have to slowly wrap up. Yeah. Well, let me quickly talk about these roles and functions. So platforms create and govern infrastructure for access to personal data, and they facilitate data-driven services. And I think you can distinguish 3 levels. And so first, they establish technical mechanisms and standards for privacy governance. They establish the contractual standards for privacy governance, terms of service. And then they engage in monitoring or not, of course, monitoring and enforcement of relevant practices of business users. So then platforms become sites for the establishment of user trust and the optimization of user engagement. And they bridge different regulatory requirements in their transnational operations. And I think this is like a very important part, actually, of how they end up relating to law in specific ways. And they start to kind of the way that they translate legal requirements to their technical designs and standards so that they can facilitate activity across all sorts of jurisdictions. And then they engage in stakeholders, of course, in regulatory discussions. And in the end, they strike this balance between the respect for data privacy and data-driven environments and the optimization of business opportunities, connecting to the specific platform and the underlying data. So then, what should be this role of platforms? These are my concluding considerations, and then we can hopefully have some discussion. So yeah, first to start, like the track record of platforms as privacy regulators is of course a very mixed bag, and it's maybe quite dubious that they end up like, you know, on the one hand they're the ones that have created these spaces for the erosion of people's privacy, and then now they would be like the regulator. They seem to be in a very dubious position. Why would we trust them to perform that role well? No? So that is a start. And if you start looking into it, like they have taken up some of these privacy governance functions, but they have done so rather suboptimally often at times, and foreclosed opportunities of third parties to step into the privacy governance role. So that is really the part where, like, you know, like there's all sorts of privacy governance functions. They are monopolized by the platforms. You know, it's not that you can, as a service, offer privacy settings on Facebook, or like offer a new, privacy settings on a mobile phone. And that is a kind of a monopolizing behavior of this privacy governance function, which is of course essential to managing these trade-offs and optimizing the value for business users. So they're very conflicting incentives, and without more clarity with respect to these privacy governance functions, they can use these privacy governance functions also anti-competitively. And there are more and more examples where apps are being targeted, you know, under like Apple has been dealing with Spotify in ways that has to do also with privacy and some other apps. And then, you know, like the question is, okay, like how are they really going about this? You know, are they being fair in the way that they administer this privacy governance role? And then, of course, and this is a big concern, that putting more and more responsibilities on platforms, it actually increases and entrenches their dominance. You know? So it's like, in a way, I mean, it's very understandable that privacy regulators are like, oh my God, millions of apps, how are we on earth going to police all of this? Like, let's let the platforms, they actually create this ecosystem, they have a lot of knowledge, and like let them kind of be the first, like the police in first instance. But it's like the more and more of that responsibility is put on platforms, that of course makes them also more dominant. And but the thing is, though, if you start really pushing and saying you have these particular roles, you have these particular responsibilities, this is what you have to do, you know, that starts to hurt their possibility to bridge these transnational differences. You know, and that is, of course, it is somewhat interesting that we have these platforms that are able to serve across jurisdictions. and that allows for some flexibility. Finally, and I think, and that is the direction in which we are looking, is there should be some type of disclosure about around how this privacy governance function is being carried out. You know, so at the moment we do not have anything of that, and we do not have requirements that say, you know, what are you doing? What exactly, like, did you do in terms of technical mechanisms? What is it that is in your contractual terms? What is it that you're doing on monitoring? What is it you're doing on enforcement? We do not have any numbers on that. You know? And that could lead to, at some point, you know, having some kind of performance. Can you see the bottom row actually? No. So transparent and performance standards for platforms in this privacy governance role. Okay, that was it.